Just one quick. Okay. It's on. Okay, welcome everybody. My name is Sonja Schmid. I'm a faculty member in the Department of Science, Technology, and Society here at Virginia Tech. And welcome to SIREN. This is the 20th event in a series of seminars, talks, and discussion on nuclear emergency response. The series is part of my NSF Career Award on globalizing nuclear emergency response. And in the spirit of this type of grant, we emphasize the importance of both research and education in the area of nuclear emergency preparedness and response. All SIREN speakers are meeting with graduate students as part of their engagement, and we plan to provide access to a recording of their lectures. SIREN, the Seminar on Interdisciplinary Research and Education in Nuclear Emergency Response, is generously supported by Virginia Tech's Office of the Vice President for the National Capital Region. Many thanks to the staff of the Virginia Tech Research Center's Executive Briefing Center and the IT team for their support, and to the students, staff, and faculty in the Department of STS for helping to make this happen. Today's talk will be live streamed. We have about 30 plus participants signed up as of this morning. And these attendees are joining us not only from our main campus in Blacksburg, other U.S. universities, good morning Stanford, I know you have a viewing party at CSAC, federal agencies, national labs, but also from abroad. Welcome everybody. And if you're watching us online and would like to submit a question or a comment to the speaker, please send an email to siren@vt.edu. Indicate your name and affiliation as well, please. And if you'd like to be added to our mailing list, we use it only to announce SIREN events. You can now join our Google group SIREN series. I also want to give you a short preview of spring 2018. So on January 25th, we'll have a conversation with Professor Robert Hayes from NC State, an expert on nuclear forensics, on emergency response at the WIP event a few years ago. We'll have also a team from the NNSA address the differences and overlaps of emergency response training and scenario design and practice in March, among others. So please stay tuned and help us spread the word. And now it is my pleasure to introduce our speaker today. Dr. Mary X. Mitchell's work focuses on the intersections of nuclear science and technology with law and social movements. She's currently an Atkinson Fellow in Sustainability at Cornell University and will join Purdue as an assistant professor in the history department next year. She earned her PhD in History and Sociology of Science from the University of Pennsylvania in 2016. And before beginning her doctorate, she worked in university technology licensing, earned her JD, practiced law, and served as a judicial law clerk to the Honorable Anthony J. Sirica, thank you, of the United States Court of Appeals for the Third Circuit. Dr. Mitchell's research explores the transnational legal histories of nuclear weapons and energy. She's completing the manuscript of her first book, which is titled Test Cases, American Law, Nuclear Weapons, and Extraterritorial Power in the Post-War Pacific, which uses legal conflict over nuclear weapons testing to trace the contours of America's Pacific expansion following World War II. She's concurrently involved in research for her next book about the history of liability, insurance, and compensation frameworks for nuclear reactor incidents. Dr. Mitchell has published articles in Environmental History, the Journal of the History of Biology, and Change Over Time. And for the past few weeks, Mary has been in DC, first presenting at the American Anthropological Association's conference, and then working in the archives on her compensation project. We're very lucky to have her. Thank you for coming, and please join me in welcoming Mary Mitchell.
Well, thank you so much for that introduction. And to everyone who's here today, both in physical presence and virtually, especially to Stanford's viewing party, which I hope they have a lot of coffee, and I'll try not to bore them. So as Sonja mentioned, I'm excited to share research from a relatively new book project on nuclear disaster liability that I've been working on for about the past year and a half while I've been at Cornell. And I'm going to talk today about liability for transboundary harm from nuclear reactor incidents, and more specifically about how the Chernobyl incident highlighted the tensions between the movements of transboundary fallout, territorial sovereignty of states, and a ragged international legal regime that had been developed to govern reactor incidents. Now, the work that I'll present today draws on published primary sources and on extensive archival research in collections from the International Atomic Energy Agency, which I'll refer to as the IAEA for short, the Organization for Economic Cooperation and Development, or the OECD, the European Union, and the US Presidential Commission on Catastrophic Nuclear Accidents that convened in the late 1980s. I'm very grateful to have been granted access to these organizations' papers. I'm particularly grateful to IAEA and OECD, which played integral roles in establishing liability regimes and which very generously opened their archives to me. Now, as I mentioned, this is quite a new project for me, so I'll be eager to get your suggestions for developing this work. I'm basically just at the point where I'm beginning to formulate cogent thoughts about it, and I still have a lot of archival and interview work to do, and we'll begin writing about this soon. So the work that I'm going to present draws on, as I mentioned, on these archival collections, but I'm going to start actually in 1974 when Otto von Busekist, the head of legal affairs for the OECD's Nuclear Energy Agency, observed that, quote, "The future will bring a growing public concern about nuclear third-party liability, which, I dare say, has played some sort of a Sleeping Beauty's role within the past decade. It has been discussed almost exclusively within restricted circles, sometimes in rather academic fashion. The public," he observed, "will play the role of the prince that will awaken the Sleeping Beauty. It will want to know, for example, whether the maximum amount of liability will be sufficient, whether the state's prepared to intervene in cases of catastrophic incidents, and whether it is adequately protected by an international liability regime." Just over 12 years later, of course, in the wake of the 1986 Chernobyl catastrophe, these marks seem prescient. As fallout from Chernobyl wended its way all over Europe and, in fact, worldwide, IAEA Director General Hans Blix remarked to the Board of Governors that, quote, "The public had discovered that there is no effective liability regime in existence." So today I want to explore why some 30 years following the growth of the nuclear power industry in the 1950s, the international community had not yet agreed fully on how best to compensate victims of a catastrophic meltdown, especially one that, like Chernobyl, had transboundary effects and transboundary consequences. This wasn't due to a failure to comprehend the risk or the scale of a potential disaster, and it wasn't due to a failure to regulate. Actually, beginning in the 1950s, nuclear nation states and international organizations crafted liability regimes to address some of the contingencies of nuclear power. I'll argue today that the compromises and the gaps built into these regulatory regimes, especially at the international level, were present from the outset. As I'll explore today, these regimes were curious artifacts of the international promotion of nuclear power, the reliance on private industry, and the unwillingness of nuclear power states to give up a portion or a modicum of sovereignty in order to enable or encourage more robust regulation at the international level. Chernobyl's transboundary effects, which you can see here on the slide, exposed some of the limitations of these legal regimes and brought renewed discussion of instituting a more robust program of state liability. The horrific accident, however, failed to prompt major changes or major overhauls. And today I want to explore how and why that happened, how this massive technological failure did not prompt a regulatory overhaul in the field of liability. Now, this material raises important questions at the intersections between science, technology, and law. There's been a renewed interest and a groundswell of interest on regulatory regimes within history of science and technology. For example, I'm sure many people are familiar with Gabrielle Hecht's exceptional work, or excellent work, I shouldn't say exceptional, on the flexibility of regulatory regimes governing uranium mining. A number of other historians of science and technology, meanwhile, have explored the role and production of scientific doubt and uncertainty, especially within legal systems, and we have Kate Brown here today who's talked about that in the wake of Chernobyl. I build on these works, but because of my background as a lawyer and as someone who's also trained in legal history, I supplement them with insights from socio-legal studies on contentious legislative processes. What do lawmakers do when they can't reach agreement? How are controversies bracketed or intentionally held open within a regulatory regime? How are these compromises maintained over time, and what does it take to upend them? So working from this perspective, I think, suggests the importance of certain features of law and regulation. For example, the abductive, analogic form of legal reasoning, and of course, the interpretive labor that goes into elaborating regimes over time. It also points to the scale and importance of human intention and human agency in the maintenance of regulatory regimes. The regimes that I'm going to discuss today are imperfect not only and not principally because of the features or endurance of the underlying technology itself, but because powerful persons and interests invested political and financial capital to keep them in their current form. These insights are not just important in nuclear, of course, they spread across technological fields because regulatory templates and frameworks very often set the terms of engagement. They define an authoritative field of conflict that constrains who can argue and what they're going to argue about. Once set, they can be difficult to change, which I'll show today. And regulation in one technological field, moreover, very often has downstream influence on other fields, and this was the case in nuclear. This is both because of the weight of legal precedent within common law systems, but it's also because lawmakers often use existing regimes as a template or a model when they regulate in new and emerging fields. So I'm going to spend just less than half my time today elaborating about the genesis of these international liability regimes. I'm going to then devote the remainder of the talk to talking about the reaction to Chernobyl. And I'll conclude with a few thoughts appropriate to the SIREN venue about what this fraught history means for nuclear regulation going forward. So to begin with, I want to sketch out how and why these international multilateral conventions on liability came out and operated prior to Chernobyl. International interest in liability over a reactor meltdown began during the 50s as the United States promoted nuclear power abroad in furtherance of its foreign policy aims. War-torn countries in Europe and East Asia were then working to rebuild, and affairs had become increasingly unstable in the Middle East during the late 1950s, threatening the supply of oil. Nuclear power appeared to many countries as essential to achieving energy security. Fostering a private nuclear industry, meanwhile, and using it as a part of international exchanges in the nuclear field, meanwhile, offered the U.S. leverage in its foreign affairs. Private insurers were interested in writing the business, but they couldn't, they thought, cover the full risk of a catastrophic meltdown. Now, scientists in the U.S. had estimated that a true nuclear catastrophe could run as high as about $7 billion US in costs of damaged property and to persons. The insurers thought they could cover about $60 million of that, so a much smaller fraction. Regulators and legislators in the US, across Europe, and in Japan concurrently began to consider ways that they might enable the growth of the private nuclear sector. National legislatures experimented with sui generis, exceptional legal regimes to govern liability for a reactor meltdown and for a major reactor incident. Now, this push, as I've indicated, for limited liability regimes actually began in the US, which was then a key producer of parts and expertise and plans. The US government, in turn, pressured allies and international organizations to create limited liability regimes of their own, similar to the ones that the US adopted in 1957 as a part of the Price-Anderson Act. Going nuclear, in this case, was a foregone conclusion, and limiting the liability of industry participants was a means of growing a fledgling industry, facilitating the participation of private insurers, and enabling international flows of American parts, expertise, and capital. It was against this backdrop that the OECD and the IAEA drafted international conventions governing liability for reactor meltdowns. Now, these were the OECD's 1960 Paris Convention on Third-Party Liability and its supplements, and the IAEA's 1963 Vienna Convention on Civil Liability. These conventions were riddled with frank problems and with regulatory silences from the outset that one participant even described as, quote, that these conventions were, quote, the lowest common denominator of a number of different interests. States were hungry for nuclear power. Industry participants, meanwhile, wanted a measure of legal certainty about where they could be sued, who could sue them, and how much it would cost. And by and large, insurers worldwide and American technology suppliers were not willing to go forward in the nuclear industry if a reactor incident could force them into insolvency. Nobody wanted to bet their business on nuclear. And so for their part, these international organizations actually also stood to gain from stepping in to regulate. The OECD had actually begun, and it was called the OEEC at its outset, but I'm just going to use OECD for short because people are familiar with it today. But it had actually begun as a part of the Marshall Plan in Europe, working to redevelop Europe. But by the late 50s, it was developing its own distinct identity. And it saw in the nuclear industry a possibility of defining itself that could take a role in emerging fields. The newly formed IAEA, meanwhile, which itself was part of Eisenhower's Atoms for Peace plan and was then run by an American, Sterling Cole, sought to cement its authority as the only truly international regulator open to participation from states worldwide. The OECD, by contrast, was mostly a Western European organization in this time period. And so the resulting conventions resulted from long deliberations of expert committees staffed by lawyers and insurance experts. To give you an idea of what these committees looked like, the OECD's committee, for example, had 19 participants, 8 of whom were lawyers, and fully 9 of whom had ties to the insurance industry. Technical drafting in these expert committees was followed by contentious back-and-forth negotiations between state delegations. So in order to discuss the aftermath of Chernobyl today, and actually to get to that, I could talk about the conventions themselves all day, and I don't want to do that to you. I want to briefly summarize the main pillars of these conventions, and there are 5 of them. The first pillar on which these conventions rest is that liability is channeled exclusively to the operator of a nuclear plant. That is, only the plant's operator may be held liable for an incident. This has 2 important implications, or at least 2 important implications. First, it means that suppliers, so part suppliers, people who are supplying plant designs, cannot be held liable even if their parts, even if what they supply is in fact defective, and even if they're at fault. Second, both of these conventions sound in private international law rather than in public international law. In other words, the conventions don't govern the liability of states to one another. Rather, they place the burden on individual claimants to file civil suits against the plant's operator. Now, the operator itself may, in some cases, be an arm of the state or a quasi-state entity, but the state isn't liable per se for the harm that it causes, either to its own residents or in a transboundary context. Now, the IAEA had actually, at the outset in 1959, initially suggested that a regime of state liability be put into place instead of or in addition to this legal channeling regime. That suggestion was quickly panned by some participants as, quote, a gimmick that they felt had been promoted by IAEA as the institution worked to carve out for itself a new field of influence, and it was dropped almost immediately. Among other things, addressing state liability, so the liability of one state to another, for reactor fallout was politically unpalatable, especially for states like the US, the UK, the USSR, and France, all of which were then concurrently engaged in atmospheric nuclear weapons testing. Creating a source of state liability for fallout from a reactor threatened to suggest that there could be liability for weapons fallout. And this was an issue that these nation states did not want litigated, did not want to be able to be litigated in an international venue. These states, moreover, most especially the US and the USSR, remember this is the heart of the Cold War, had repeatedly offered a vision of their own sovereignty as an indefeasible unit. So essentially they had shown themselves pretty much unwilling to submit to outside regulation or to limit their own actions within their own territory. And so they wanted to reserve within their own territory basically the full authority to act in the nuclear power field. Equally as important as these political concerns, however, the decision to focus on private law also reflected the position of private businesses within the international nuclear power industry. Pierre Boulanger, who headed the IAEA's legal division toward the conclusion of negotiations of the Vienna Convention, remarked frankly that a state liability regime would threaten the participation of private insurance and private industry in the field of nuclear power. And he said this was in a public forum, actually, that he basically discussed these issues. The conventions, therefore, presupposed, and indeed they were crafted around, the promotion and a participation of private suppliers, private operators, and private insurers. And this brings us to the second pillar, which is strict liability is imposed upon the operator. So the conventions don't require for anyone to show fault. Basically, if there's an incident, the operator is liable, full stop. And this pillar basically reflects the developing approach in the 1950s of many states to high-risk industries, namely that the creation of a risk itself could be a source of liability rather than any fault. And in complex industries, this is particularly important because it can be very difficult to figure out where fault lay. The third pillar is financial protection. An operator must carry financial protection equal to the liability it faces. Every operator had to do this, had to cover the liability that existed under these conventions to third parties, so for injured persons and injured property off-site of the reactor. In most cases, this was accomplished through the purchase of private insurance, though a company could also self-insure or a state could provide insurance. The fourth pillar is the limitation of an operator's liability in terms of time and money. Now, the conventions require that there be a financial cap on liability and that there be a limited time horizon in which a claimant can sue. These provisions limit uncertainty. They circumscribe the risk that an operator can face. The time limitation on suits at the time of negotiation of the conventions was just 10 years. And of course, this limited liability by foreclosing recovery for latent injuries, which often arise at the 20 or 30-year mark. In terms of financial limits, at the time of drafting, the Vienna Convention set the compensation floor at just $5 million US, while Paris was tied to a gold standard that equaled roughly about $15 million US. So that's in comparison to the overall liability exposure, which was estimated to be as high as $7 billion US in the same time period. Now, these limits were low. The head of IAEA Legal, Pierre Boulanger, who I mentioned just a moment ago, called them actually in this public forum, quote, unbelievably low and utterly insufficient. And across both conventions then, what drafters did, or what state delegations did, was simply analogize nuclear disaster to a natural disaster and suggested that the state would just step in to cover any uncompensated losses. The fifth and final pillar in these conventions has to do with court jurisdiction. Basically, court proceedings are to be located in the courts of the state where the meltdown occurs. This, again, a limited uncertainty of operators. A plant operator could have a better idea of what laws of legal procedure and what substantive law would apply to its plant. And this substantially limited problems over conflict of law and allowed industry participants basically just to plan. So the conventions, as I mentioned, were imperfect products that were known to be imperfect and seen as imperfect at the time, and they were products of taxing negotiation. Expert draftspersons tried very hard to develop more robust private law system and to accommodate better protections for the public, but state delegations pushed back. And I should say, as an aside, in going through thousands of documents from these negotiations, I actually have a lot of empathy for the lawyers who were tasked with negotiating these. They tried really hard and over many, many years, and this must have been a very frustrating process. The resulting conventions created regulatory gaps, particularly concerning the territorial scope of coverage of the conventions and what would happen in the case of a transboundary accident. Drafters left open for future resolution issues of when and whether the conventions would apply if one state were a signatory of Paris and one state were a signatory of Vienna, or if one state were signatory of one convention or of any convention and the other state was not a signatory of a convention. They also left open questions of what would happen if damage occurred in an area that wasn't under the jurisdiction of any nation state, like the high seas, for example. Recovery for environmental damage, moreover, was left out of the drafting process. Adding confusion to this already muddled situation, the two conventions also conflicted with each other, as you might anticipate from there being two separate bodies working on them. Paris was only open to OECD members, that was mostly Western Europe in this time period, and Vienna was open to any state. This distinction affected also the financial coverage that was provided by each convention. So as I've mentioned, Vienna was lower, about a third of what Paris would provide. And this created the potential for problems to arise, problems of reciprocity to arise if two states were signatory to these two different conventions. These problems were further exacerbated, as if they needed any help here, by low rates of adoption and ratification of the convention. As of 1986, signatories to the Paris Convention included only 14 Western European member states. Signatories to the Vienna Convention included just 10 states, most of which were in Africa, Asia, and principally Latin America, and only one of which even had an operating nuclear plant, and that was Argentina. Japan, the US, and the USSR, meanwhile, three of the largest producers of nuclear kilowatt hours in 1986, and I should say, ultimately, the three states that experienced major nuclear reactor incidents, didn't join any convention. Overall, only 31% of worldwide nuclear energy kilowatt hours occurred in a nation that was a signatory to one of these two conventions, and those are figures from 1986. So even though nuclear harm was widely understood to be a transboundary problem, nuclear liability consequently remained mostly a matter left to individual states. The conventions played a role in setting standards and enunciating principles that did help to harmonize many national legal regimes, but major producers had declined to accede within these international liability regimes. The resulting patchwork of domestic law, international convention, and regional or bilateral agreements solved immediately some of the immediate transboundary harms of nuclear energy, which is they fostered the growth of an international, partly private nuclear power industry. But these conventions and other sources of law left aside the most vexing aspect of transboundary harm. Chernobyl brought this ragged liability regime, complete with its many gaps and deficiencies, into sharp focus. Just a few months after the Chernobyl disaster, in August of 1986, European Community Representative to the IAEA, Sir Christopher Aldland, reflected in his private notes that, quote, as Chernobyl was to reveal, very little work had been openly done on how one could cope with a reactor accident of such magnitude. There had been a lot of reticence on the part of public authorities about allowing people to know what had been done. So now with the transboundary harm of Chernobyl in view, in 1986 and in 1987, new controversy emerged at the IAEA over the interplay between state sovereignty to act in the nuclear field and liability for transboundary harm. The Sleeping Beauty, to use a phrase that was previously mentioned, had found her prince, and I won't unpack the strange gendered conceptions of that analogy. The IAEA had been tasked, of course, not only with international regulation of the nuclear field, but also with its promotion. They were frankly tasked with promoting nuclear power. Following Chernobyl, then, the institution was concerned not only about safety, it was certainly concerned about safety, but it was also concerned about public relation problems concerning nuclear power. As member states of the IAEA dealt with contamination and increasingly fearful publics at home, the liability regimes became a source of discussion. These disputes unfolded at IAEA, of course, which took the lead in coordinating the international response to Chernobyl. The debates quite quickly began to center on nuclear power states' unfettered rights to regulate nuclear technologies only at the level of the state without subjecting themselves to binding international regulation. That is, these disputes quickly began to turn on sovereignty. States including France, India, Brazil, and the US argued vigorously against the extension of binding supranational regulatory authority that would be capable of addressing problems of transboundary harm. I don't always have the reasoning on why this was the case. The records aren't complete. But to give an idea of what might have been behind this, for its part, the US expressed some of its motivations internally within its delegation, explaining that, quote, because of the importance of nuclear power to the energy security of the United States, we're determined to do what is necessary to ensure its continued availability. So this statement wasn't promulgated directly as a result of discussions about liability, but it gives some sort of idea of what nation states' motivations might have been. Controversy fomented then over the inequitable distribution of the benefits and the burdens of nuclear power. Argentine Governor Gonzalez explained that, quote, one can discern doubts and hesitations, particularly on the part of countries with a high level of nuclear development, about approving specific actions to be taken by the agency. Some countries, he said, seem to want to enjoy the benefits of nuclear energy, while the majority of member states were left to suffer the inevitable harmful consequences associated with its use. So this was at the core, as the governor from Venezuela, Sucre Figueroa, remarked, and Toranud of Finland agreed, quote, a very thorny problem of sovereignty. If, as Chernobyl proved, fallout from a reactor incident could transcend the territorial boundaries and the territorial sovereignty of nuclear power states, shouldn't those nuclear power states bear a greater responsibility to those that might be harmed? By late 86 and early 87, the USSR actually had somewhat curiously become the erstwhile champion of drafting a new convention that would address precisely these problems. Now, in some senses, this was a weird development. As the next slide suggests, the USSR was thought in this time to be quite reticent to come clean about Chernobyl and to address its effects. The USSR, moreover, had declined to enter into any convention on international liability. And in addition, it had long hewn to very strong versions of state sovereignty and eschewed many forms of international regulation. But in other senses, the Soviet desire to see a new multilateral convention on state liability made legal sense. Soviet legal theorists had rejected private international law, full stop. They refused to recognize natural or corporate persons under international law as appropriate international actors. In widely held views, Soviet legal theorists thought the state itself was the only appropriate party to enter into an international law agreement, such as one governing transboundary harm. But rather cynically, I think, there was something else behind these new Soviet calls for state liability. The call for a new multilateral instrument on state liability underlined the tenuous legal basis for then possible claims against the Soviet state for harm flowing from Chernobyl. Describing the lack of coverage of international state liability as a, quote, serious inadequacy, in February of 1987, the Governor Semenov from the USSR reiterated his earlier urgings for a new convention. And in doing so, he surmised that, quote, at present, one had to assume that there was no guarantee that damage caused to individuals or to states by a nuclear accident would be duly compensated. These statements, of course, which he repeated on multiple occasions, suggested that the USSR would take a firm stance that it had no existing legal obligation to pay other nation states that had been affected by the Chernobyl meltdown. European Commission member states, many of which had themselves suffered effects from the meltdown, were then developing compensation programs for their own citizens, and they had come to the same conclusion the summer before. Although they identified several legal theories under which the states or their citizens might sue the USSR for the transboundary harm, they concluded that a suit was unlikely to be successful, and they were worried about two things. They thought the USSR would be unlikely to enforce a judgment won in another court. So if a judgment were won, for example, in an Austrian court, they didn't think that the USSR courts would enforce the judgment. And secondly, they thought if the states or if foreign citizens sued in the USSR courts, that the USSR's own courts would not treat those claimants fairly. So they decided, they made a pact that nobody would sue without consulting the other European Commission member states. Despite this tension between the USSR and its European neighbors, it found some of its strongest support on the issue of developing this new convention from them. An Austrian representative who was president at the IAEA Board of Governors meetings in December, for example, urged the creation of a new convention. Gleisner explained that, quote, the procedures foreseen by the two conventions did not include any procedure for the settlement of claims for damages under international law. The idea of limiting international regulation of liability for nuclear damage to a system of claims presented individually to civil law courts was simply not practicable, given that a singular nuclear accident could cause damage to thousands of persons. Austria was joined by other affected states, such as the UK and the Ireland, which likewise supported a new convention on state liability. And they were joined by states like Luxembourg, Canada, Egypt, Nigeria, Chile, and many, many others that were less affected or unaffected by Chernobyl, many of which didn't enjoy any of the benefits of nuclear power, right? The only exposure of some of these states was to the harms. And so amidst growing calls for reconsideration of state liability, from the records that I have access to so far, it seems like the nuclear behemoths, the major nuclear power producing states such as the US, France, and Japan, sought to actually quiet the issue. Nation states like France sought to place the emphasis on expanding signatures to the Vienna Convention and on harmonizing Paris and Vienna, so making these two conventions work together rather than being mutually exclusive. This position gained wide support among members of the Board of Governors. It was a relatively straightforward way of filling some of the gaps in this regime without touching the controversial third rail of state liability, which implicated state sovereignty. Doing this also would avoid upending the bargain on which these conventions were based. That is, the assumption that nuclear capacity ought to be promoted and private industry participation also ought to be promoted. Other nation states, including Japan and the US, pressed explicitly and implicitly to slow walk questions or discussions of state liability. Delegates routinely urged extreme caution on proceeding in this field, not least, they argued, because transboundary harm for a reactor incident could have implications on other fields of liability for transboundary pollution. Japan's Tsukuda, for example, called for the board to proceed, quote, slowly but surely. The US Governor Kennedy suggested that the frameworks governing liability, quote, would have to be examined in a deliberate and conscientious manner. The temptation to make haste on the pretext that domestic public opinion needed a palliative would have to be resisted. And indeed, these interests were very successful in not making haste. Things proceeded very, very slowly, discussions of state liability. And in the meantime, IAEA and OECD convened yet another drafting panel of experts. They turned first to harmonizing the Paris and Vienna conventions. That happened in 1988 in a protocol that came into force in 1992. So that's actually a pretty quick process in terms of international law, even though it's a number of years after Chernobyl now. But where that protocol had been concluded, discussions over state liability and mending the gaps in existing regimes dragged on for years. Now, I can't comment on specific motivations or tactics of different delegations because archival restrictions have so far limited what's available to me, especially after the beginning of 1988. But I can give a rough sketch of ultimately what happened and the time frame on which it took place. Now, I know this is going to be a shocker to our audience today, but no action was taken on state liability. IAEA redoubled its efforts to shore up Vienna and Paris, and it took some efforts to actually increase the amount of financial security that an operator would be on the hook for, and to impose on signatory states some new obligations for the state to provide a pool of funding as well. Some other amendments introduced as late as the early 2000s, so after over a decade after Chernobyl, did things like enable but did not require signatory states to cover environmental damage. Still, other amendments extend the time limit on personal injury suits to 30 years, and of course, this covers more of the latent injuries like cancers that can arise from radiation exposure. So I want to be clear, these are definitely improvements. And I know that a dedicated workforce of experts at both of these institutions, at IAEA and in the OECD's Nuclear Energy Agency, for whom I have a tremendous amount of respect, have dedicated their careers. They've worked very, very hard to improving this situation. But despite their efforts and a wellspring of good intentions, these improvements don't go far enough. There are limits to what any group of experts, moreover, or any international organization can achieve without buy-in from nuclear power states themselves. For its part, in response to Chernobyl, the US introduced yet another private law international convention, so a third one that would compete with Paris and Vienna. This was called the Convention on Supplemental Compensation for Nuclear Damages. Its negotiation lasted fully 10 years, from 1987 to 1997. And in the broadest strokes, this new convention mostly dictated funding levels rather than suggesting what legal principles had to underpin them. And among other things, it created a second tier of pooled compensation that would be provided through retrospective payments by the signatory states if an accident actually happened. Now, when the Fukushima meltdown happened in 2011, causing substantial transboundary harm to the Pacific Ocean along with harm to many people in Japan, the CFC had not yet entered into force. And it wasn't until 2015, so almost 30 years after Chernobyl, that it came into force when, ironically, when Japan acceded to it. And today, these three regimes, the Paris, Vienna, and CSC regimes, form a confusing, imperfect, and grossly underfunded regulatory patchwork that governs liability, especially in the transboundary context. Although when you add them all together, there are 8 total conventions and supplementary protocols, some of which haven't even entered into force yet. They still have very few signers today. Some of the major nuclear power states, like China, are left completely out of these frameworks, and many nuclear power states have elected not to sign for what I think are fairly obvious reasons that I'm not sure how it would benefit them to do so. So I've listed some of the overall financial coverages that these conventions provide for here on this next slide. What you'll see here is that the amounts of funding available, of compensation funding available, though expanded from what they were at the outset, are still shockingly small. And in many cases, they haven't indexed to inflation either. So that's another, I just want to put a pin in that. So these aggregate amounts include both the operator's obligations and more recently added state obligations to provide some funding. So I'm taking those two pools together. The amounts that are provided are a bit of a double-edged sword. On the one hand, they represent the amounts of compensation that should definitely be available if a reactor meltdown happens within a signatory state. But on the other hand, they can act as limitations on the amount of compensation that's available. A signatory state is not obligated to ensure that operators are able to cover more or that states would provide any more than what's listed here. Now, while some states choose to provide larger pools, the US, for example, guarantees about $13.1 billion US dollars. Even the most robust systems, like those planned for in the US, fall grossly short of the cost of a catastrophic meltdown. We only need to look to Fukushima for proof. As of November 2016, the Japan government estimated that compensation to victims and cleanup costs would top 180 billion US dollars. And I think that estimate's actually crept upwards in the intervening time, not least because there's ongoing litigation in the courts about these issues. So despite not one, but 2 massive catastrophic disasters having transboundary effects, these imperfect civil law liability regimes have remained in place. Whatever these conventions do accomplish, I think it's a stretch to say that they protect publics in nuclear nation states or in states that might experience transboundary harms. Rather, these regimes largely preserve the freedom to act of participating nation states while fostering the nuclear power industry, the private nuclear power industry, and the insurance industries by encouraging limits on legal and financial exposure. The assumptions, meanwhile, means that states will step in when something goes terribly wrong. And as regards transboundary harm, there's still no clear mechanism for states to recover from one another. Instead, the burdens of such harms, as they have in the past, are likely to fall largely on victims themselves, wherever they may be. So I think it's clear that there needs to be more open discussion and consideration of these issues. I want to be upfront here that I think there may be good reasons why states would want to continue in this vein and to continue to prop up the nuclear power industry today by sticking with these regulatory models. The reasons for creating the regimes in the 50s, for example, energy security and foreign policy concerns, may still hold today, or they could be supplemented by new concerns such as reducing carbon emissions or maintaining a reserve technical workforce. But governments and international regulators alike have failed not only to plan in advance, to allocate sufficient funding, and to produce an equitable means for handling claims, they've also failed to articulate contemporary justifications for these systems. While both Chernobyl and more recently Fukushima prompted discussion of liability regimes, They're still negotiated principally in expert committees within individual nation states and also within the international organizations. The public hasn't really been brought into discussion in a robust way. Many of the same problems of transparency and of planning for nuclear catastrophe that the European Commission representative Sir Odland identified in 1986 actually remain today. In August of '86, he had asked himself rhetorically why participation and transparency had been so limited. And he obvious. The authorities, aware of the potential scale of the damage which could flow from a major reactor accident, had preferred to keep quiet and hope that none would occur, rather than to give publicity to facts which could have fed opposition to the use of nuclear power. But I believe that another part of the answer, though less evident, is also important. The habit of secrecy spilled over from the military to the civilian side. It's publics that stand to bear the harms and the costs of recovering for their injuries. Yet those same publics remain very ill-informed about the admittedly Byzantine regulatory regimes. They don't know what will happen to them if they are harmed by a reactor meltdown, what damages they might be able to recover, who would pay for it, or how compensation would be meted out, what process would be used. Colleagues that I've been very lucky to work with over the past year and who are working on Fukushima have shown me that the unsettled nature of nuclear compensation systems itself has further harmed communities that were already suffering from the disaster. These problems would only be exacerbated, I think, in the case of a meltdown that affected more than one state, that affected citizens of more than one state. So to conclude, as long as nuclear power remains a source of electricity, and I think there's a good indication that it will, incidents are going to happen. The sheer number, size, and productive capacity of existing nuclear power plants virtually ensures a major future accident. And this is the case even if we don't take into account things like the poor state of maintenance of some of these plants, the outmoding of much of the older portion of the nuclear fleet, and plants in states that don't have very robust regulatory systems. If governments continue to support nuclear power industries through limited liability regimes at the national and international level, I think they ought to be required to justify their support and to specify and clarify whatever recourse injured members of the public may have after a major catastrophe. Perhaps more than other technologies, nuclear technologies have become emblematic of state power. I think states need to step in to sort out the differences between the nuclear industries they support and the people who bear the risks and the burdens of nuclear power production. Thank you.
Figure out what's going on with our technology.
Okay.
But in the meantime, I would like to invite you for any questions or comments you might have for Mary. Also introduce yourself, please.
This is, it doesn't seem like it's working, but in case it is, I'm Kate Brown from UMBC, and it seems like regulations and liability law is just the tip of the iceberg, right? If you're going to prove damage, you have to have a whole infrastructure to measure damage, measure it environmentally, to measure it in the bodies of people. In the United States, we have a really poor record of that, of going out and, after 3 Mile Island, no radiologist, showed up to look at the, or health physicists showed up to look at the bodies of the people who had been exposed around the 3 Mile Island plant. And when the state director of public health announced 9 months after the accident that there had been a rise of babies born with thyroid problems, there wasn't an investigation. The governor just fired him. So, at some point, the legal culture clashes with a whole nother set of problems. So even if people won liability that wasn't limited and wasn't based on insurance, they still would have a very hard time proving damage.
Yeah, absolutely. Radiogenic injuries, radiogenic cancers in particular, have indeterminate causation. So you can't tell from a tumor in most cases whether the cause of the tumor was something else or whether it was a radiation injury. And you'll note that, so although these frameworks remove fault, so that a claimant doesn't have to prove that it was the fault of the operator, they can just sue the operator, they still have to prove damage causation. as you mentioned, and this is a real contentious issue. The U.S. considered this issue actually after Chernobyl in the Presidential Commission that I mentioned in 1989 and 1990. And this was, to my mind, the first time that a mass nuclear disaster was treated in the same sentence and in the same sort of thought procedure with other forms of mass torts. And there was discussion then to move to models in mass settlement of probability of causation, sometimes called assigned risk, or assigned risk. And ultimately, though, the work of this committee was basically just scuttled, and the committee members made jokes about it at the time that this was sort of not going to get much leverage. So, I mean, those questions still are a problem. I think more likely than not, what you see, at least in the U.S. context, and that's what I'm most familiar with in the litigation side, is that if the claims are and this is true across many complex litigations, if the plaintiffs have claims that look like they're pretty good claims, that's basically a sort of creates hydraulic pressure, as one legal commentator put it, to settle. And these settlements happen typically, these are in class actions. The settlements get vetted by the courts. So this sort of moves from litigation to administrative settlement procedures. This is what we've also seen in Japan, where the settlement, the sort of settlement or the compensation distribution became an administrative process that was actually based, I think, on no-fault traffic accident model. So yeah, I completely agree. But if the money's not there, people aren't going to recover. So I think you deal with money first, and then if people have good claims, and in some cases they will, like for example, acute myelogenous leukemia is very, very often tied to radiation. If the people have good claims and the money's there, then the next stage is sorting it out. And I think there needs to be more attention to that process as well.
Any other comments, questions? I also would like to encourage our online participants, if you want to send in a comment or a question, email is open, siren@vt.edu. Well,
it's on, right? Okay. Hi, my name is Toshi Higuchi from Georgetown. I think I'm very interested in this kind of topic, as my own first book actually talks about the legal dispute over the bikini incident, Lucky Dragon incident in 1954, and then eventually, like you just said about the out of court settlement. Basically, the U.S. and Japan chose lump sum payment ex gratia without really acknowledging any legal liability in it. And then I think on the one hand, we see the movement to legalize, the kind of standardize this kind of legal procedure. But as also Kate said, sorry, I think for the states, like the United States and others, actually, it's also convenient to have some kind of a leeway or some kind of flexibility in choosing, right? Either way. And I think might be interesting to take a look at this kind of extra legal kind of record of settlement, as on the other hand, we have a kind of a trend to install a legal regime. And then the second one, which is related to my first kind of comment, is I'm interested in the history of nuclear-powered ships. And then I noticed that the operation of nuclear-powered ships required a really robust liability regime before even putting that into the high seas, obviously. And then so there was a convention concluded in 1962. I just wonder, if you're a legal expert, if you see any interesting characteristics or kind of unique problems that were posed by the putting reactors on ships as opposed to putting reactors on land. And that would be great if you know anything.
Okay, these are great questions, and I'll deal with your first question first. So in my first book project, actually, I deal with these threats to sue and these ex gratia compensations. So an ex gratia compensation is one that happens without any admission of guilt or of fault. And this is how the U.S. largely decided to deal with its nuclear weapons testing issues, was whenever there was a threat of a suit. For example, Japan was very active in threatening to force a lawsuit before the International Court of Justice over American atmospheric weapons testing in the 50s. And what the U.S. did was to provide a settlement payout. This was also the case in various times and moments with downwinders, with Marshall Islanders, and the like. What's so interesting about the civilian nuclear power industry, and I'm going to speak to the U.S. here because it's the basis of most of my experience, is that for power, they created a legal regime from the outset. So that the move in weapons testing that I start with in my first book was to make sure that these cases never got into court. There was a worry that bringing them to court would add credence to people's claims, that in the US, the courts are a really authoritative venue in which to make these arguments. And they didn't actually want the arguments against testing, arguments about why it might be illegal under either US or international law, to be given an airing. And that's why there was the move toward settlement ex gratia. In the reactor context, actually, Price-Anderson Act, which gets generated in 1957, but it's discussed for a few years before that even, discussions started in 1954, the power claims are pushed directly into a legal regime, and it's assumed that they'll be litigated. And I've asked myself often, like, why is that? What's going on here? And it comes back to private participation of industry. It's really hard to sue governments. So there's a doctrine of sovereign immunity that limit the liability of states to their citizens and to others. So it's very, very hard to pull off a lawsuit against, for example, a military that's doing weapons testing. The converse is true for private industry participants. They automatically had liability. It had to actually be removed. And so that's the basis of the distinction that I think we see between power and weapons. For your second question about the Belgian Convention on Liability for nuclear-powered vessels, I actually have the records on the negotiation of that convention. I haven't looked as in-depth at them so far, but you're very right to point out that a ship creates very peculiar legal questions because, of course, the law that applies on a vessel is the law of the state that flags the ship. And a ship can be run by an American corporation or American nationals and still have the flag of another nation state. And it's actually kind of ironic, since I work on the Marshall Islands, that the nuclear weapons testing in the Marshall Islands, the islands have become one of the key places that flags the international fleet. So you'll see these ships that are run by American corporations, they're flying the flag of the Republic or the Marshall Islands. And what that does is it means that the law that applies on the ship is the law of the flag state, not the law of the operator. So it's a very curious legal regime where the ships carry the law with them as they move. And this was seen to create problems also with where they would come into port because, of course, there are territorial waters that extend about 12 miles from baseline of the shore. So if you go into a port, you're under the laws of the state whose territorial waters that you're in. So this was a problem. And of course, as Atoms for Peace progressed, they created this nuclear demonstration ship called the Savannah, which is one of the most curious things that I've seen in the archives, that they wanted to be able to take around to show off how cool nuclear-propelled vessels would be. And this immediately became a problem under international law. My understanding of that Belgian convention is that it didn't attract a lot of signers. The U.S., for the most part, which was producing, Rickover's nuclear vessels, nuclear fleet, this was mostly a problem with the U.S., and the U.S. preferred to negotiate bilateral agreements with the places where it was going to port its ships. I think Davide Orsini, who I hope is watching someplace in the ether, has worked on this question in the context of Italy. So there's certainly more to do. It's a peculiar problem. It mirrors in some ways the aspects of liability that have to do with planes. And of course, the craftspersons of these international conventions for nuclear liability did look to air traffic as one example. They looked to floods and air traffic, so things that move and massive disasters when they were crafting their own templates.
And just to piggyback on that, it would be interesting to play that through for floating reactors, who are supposed to.
It was considered, yeah.
Oh, to put them under the Belgian Convention?
No, but the legal problems are crafting a convention that would cover floating reactors was something that's been considered. And again, I think I looked at my laptop before I came here today. I think I have like 22,000 pages of documents on this project so far. So I just haven't been able to go into every area. And this is very abstruse areas of law. And I'm still, kind of a learner as much as I'm becoming a writer.
Thanks. Any other questions from the audience here? If not, I have a comment or a question from CSAC. Anna Weichselbraun writes, in response to the quote you have from the Austrian representative, we were curious about whether individual claims could be collected into a class action suit, as is done in the US, or if that is a modality that is not available in all legal systems.
So this idea of bringing aggregate claims or aggregating a class or a mass action, still in development in this time period, even in the U.S. Like this is a change in the 1950s that actually happens in the U.S. Judicial Conference, so in the judiciary itself, to change the rules of procedure to allow for aggregation of claims. When it was started in the U.S., it was actually started to enable civil rights claims. So this was about race in the U.S. And crafty lawyers decided it could also be about mass torts or environmental problems. As to whether such modalities exist in other systems, I think that they do, although I believe that the U.S. is known as the place where the class action vehicle is the most perfected. But there's problems with, so even in the U.S., there are issues with the class action vehicle. You have to prove commonality, and there's a number of different things that you have to prove to show that your class coheres. And that can't always be done. So in the 3 Mile Island litigation, for example, that was not a class action. It couldn't be maintained as a class action on the injury claims outside of the 20-mile zone of compensation. It had to be done as a mass or a mass action, actually, which is different. A class action, you'd bind all of the litigants via collateral estoppel, so you can just deal with the litigation once. A mass action, you can't. You can try some common issues, but you can't ultimately treat it as a class. The other benefit of the class vehicle is that the claims can be settled in one go as well. And that settlement is, again, overseen by the US courts. So I think the question of how you aggregate injuries is really important. And this gets back to the problem of damage causation. On an aggregate level, it's possible by epidemiological studies in the case of radiation to attribute a certain number of cancers or an increase in the rate of cancer to a radiation event. But the problem comes when you break that down into individuals. You can't. So if you have a class of 100 people, and let's say 25 of those people were going to get cancer at some point in their life anyway, and let's say there's an accident and you can attribute 10 more cancers, so now you have 35 out of 100 that are coming, and 10 of them are caused by radiation, and 25 of them are not. You end up with these classes where you're going to both overcompensate people and undercompensate people, because you can't tell within those 35 people who ought to be compensated. You end up giving money to people whose cancers were not caused by radiation, and you end up giving people whose cancers were caused by radiation less money. So these problems of aggregation run through mass tort, not just radiation injury, but also toxic cases and others. So you see this, for example, in the Agent Orange litigations as well, many, many others.
Great. I have a question here from Davide. Greetings from Italy. My question concerns liability about U.S. nuclear submarines and their circulation and harboring through overseas ports. I know that in Italy, for example, the approach of the commercial nuclear ship Savannah was regulated through a bilateral agreement between the U.S. and the Italian governments in 1964, but I couldn't find anything about military operations. So was there a dual regulatory regime?
That's a really good question. So the U.S. in this time period, at least in the 50s and 60s, was very dissatisfied with the international regimes that were getting promulgated. So it participated in negotiations and exerted itself in negotiations, but didn't sign any of them. And that meant that the U.S. fell back on its practice of negotiating bilateral agreements. And so basically the AEC, you can go, we can talk afterward, Davide, but the AEC has on file all of its bilaterals. And my understanding or my suspicion is that military operations were also run under bilateral, and that they were likely also negotiated through the AEC, although I would have to look back at some of the records that I have on those issues from my earlier project.
So I have a very basic question, since I'm a legal ignorant. When you said that, the pillars of these conventions, the first pillar was that the liability is channeled to plant operators. Mm-hmm. Even if you limit that statement to, let's say, Europe, yeah. With the Paris Convention, operators of nuclear power plants differ widely in their attachment to the nation states, mm-hmm. even across Europe, and definitely when you take the U.S. into and the former Soviet Union, probably Japan, into the mix. So how does that affect this pillar if you have operators that are very tightly coupled with the state, whereas in other cases it's completely detached in private industry? Yeah,
so the state stands in and assumes the liability of the operator in instances in which a state or a quasi-state entity is the operator of the plant. So that was the kind of workaround that they figured. They said, well, for example, France has a high level of state involvement. And they said, well, what we'll do is we'll define operator, and we'll define it such that a state can take the liability of the operator if the state's running the plant. There were a number of really definitions became really important in these conventions, as you can imagine. So, for example, the definition of what was a nuclear incident went through years and years of negotiation. This question of what is an operator and who's not an operator, went through years and years of tinkering, but that was the ultimate solution, is that the state assumes the liability of the operator, but that limited liability of the operator, not more than that, if the state's operating the plant.
Any other questions, comments? Well, in that case, please join me in thanking Mary one more time for an excellent talk. Thank you.